Okay, so that said, knowing that there's not a consensus in the evidence as to what per se levels should be, because per se levels for one person might be different from another person depending on their pattern of use. Because this science is just emerging, you wouldn't think we would have states passing per se levels for marijuana. Yet, we do. There are now 4 states that have set per se standards for marijuana. What that means is that if you are driving a vehicle in these states and you have either THC in your blood above their set standard, or in some cases, like you see in Nevada and Ohio, if you have an inactive metabolite that simply indicates you might have used marijuana at some unspecified previous point in time, you are per se guilty under the law of driving while impaired. You will see that in Virginia, cannabis and cannabis metabolites are excluded from the per se statute. I lived in Virginia when this law was being litigated, and I was in very close contact with my representatives and with the legislature, and it is not a coincidence that I was living in Virginia and in that frequent contact with the legislature that Virginia has cannabis and cannabis metabolites excluded from the state law. Now you might notice Grotenherman and colleagues, when they actually reviewed the on-road accident evidence and they assessed culpability of who was responsible for these accidents in drivers that used marijuana, they found an increased risk of accident only when drivers had THC levels that exceeded 5 nanograms, and they really didn't find a major increase in crash risk until the THC nanogram levels were close to about 10 nanograms in the blood. That's why they set that 5 to 10 potential threshold for per se levels. You'll notice that outside of Pennsylvania, the levels that are here are much lower. That's because Grotenherman and colleagues were trying to come up with a scientific standard for a per se threshold for marijuana. The state legislatures in these individual states were not looking at scientific evidence at all. In fact, these standards are actually not scientific thresholds, but they are what we call ability to confirm standards. What that means is when a blood test is taken in, say, the state of Nevada, and it's sent to a state-certified lab, that lab does not believe they can test for the sensitivity of THC in blood below the threshold of 2 nanograms. If they thought they could accurately, the standard would be 0 in Nevada. But because they can only go down to 2, they set the standard at 2 and they call it a per se standard. But it is not a standard based on impairment, it is based on the lab's ability to confirm. The only state where you see a 5 nanogram per milliliter per se standard, which does have some basis in science, is in Pennsylvania, and that is because when the law was written by the legislature, they actually asked the Department of Health to come up with standards after the passage of the law, and the Pennsylvania Department of Health, to their credit, actually did look at some of the science and did try to set a per se standard based on science. That's why you'll also notice that inactive metabolites are excluded from the law in Pennsylvania, while they're included in Nevada and they're included in Ohio. And I can tell you, having worked very closely with this Ohio law, where the original law was set to be 0 THC in the blood and 0 carboxy THC in the urine, instead they got it raised to 2 and 35, which frankly is still almost meaningless, that these numbers, the 35 nanogram per milliliter number, was simply picked out of the sky. There's absolutely no bearing in science or impairment. The legislators simply liked the number 35.
How did that horrible law come out of Nevada politically?
What about Michigan?
We're going to talk about Michigan.
You want to talk about it?
You know, Nevada's law has been on the books for some time. They're actually the first state to pass a per se standard. How it came out is generally the way it comes out in many of these states. Usually there's an accident, there's a claim somebody had been intoxicated, the police say we can't really track down on this the way we want to, we don't have a law, even though all these individuals could simply be charged under DUI. And the standards were simply picked because of the lab's ability to confirm. At the time, and Nevada's law goes back almost 10 years now, that's what the lowest thresholds labs are using when it came to drug testing. So that's the those are the thresholds they picked. What was troubling about that is you had other states that once Nevada picked those thresholds, other states wanted to follow suit. And so now oftentimes when you have these laws written, they simply use Nevada's standards, thinking that Nevada's standards were based on some science, when in fact they were simply built on that time and the lab's ability to confirm.